morning, ladies and gentlemen. Good morning. I hope that you have all been sleeping well and you are fresh as daisies in the morning. I am absolutely sure you are. Now, I'm going to start very gently with asking any one of you who actually were awake at breakfast this morning, if any one of you have seen a pair of foldable sunglasses that have gone missing. Ray-Ban, if anyone find them, I am sure there is a handsome reward awaiting if you're handing them in to me or to Betsy. So that is the announcement in the morning. So I hope that that has made you wake up. Sorry? Okay. And probably we also have some members of the audience from yesterday that is missing. So if you find them, bring them in. Yeah. Okay, anyway. Good morning, everyone. Wonderful to see you here today, and we have a very interesting program for a discussion today, and I would like to put the emphasis on discussion, because I think that we all go to conferences all over the world, and there is a lot of presentations that we are digesting during these conferences, but I think it is important that we are using this day to discuss. So I haven't discussed this with my fellow panel members here, but my suggestion is that do not be afraid to shoot in and ask a question if it's a burning question. And for sure, we are going to try to ensure that after presentations that we are using time to discuss. I think that is very important, because the problem otherwise is that we are sitting listening to presentations and we go home and we say, I didn't get the answer on the question that I really have. We really need to make sure that we have a discussion. So please see this as an interactive day. Everyone agrees? Angelo, very good. Right, the first topic for the day is about disputes. Dispute resolution, dispute adjudication, dispute avoidance, whatever we call it, it starts with a dispute or avoidance of a dispute. Dispute is at least the topic. What is not a dispute about is that we have a wonderful panel. We have a fantastic members that are going to provide us with some insight on the topic of dispute adjudication and dispute avoidance. We have Geoffrey Smith, who officially on the agenda represents PS Consulting, but he is also one of the key members of the Dispute Resolution Board Foundation. And we also have on my left, known to everyone, Angelo Bianchi, who is a consultant and public procurement specialist, and he is going to talk about the selection of the DRB members. Yeah? Now, DAB in my, let's say, procurement world and Evgeny's procurement world, everyone who is working with FIDIC contracts knows that with the 2017 version, the dispute adjudication has reached another prominence than maybe it had before, in the sense that FIDIC advocates that in the contract conditions, but it's also one of the golden principles that FIDIC has set up for when the contract conditions truly represents the principles of a fair and balanced FIDIC contract. So if you do not apply the dispute adjudication mechanism in the contract, you actually breach the very principles of the FIDIC contract. Now, what exactly the consequences of that are still to be explored, but FIDIC clearly puts a lot of importance on this, and it is definitely an important topic. Yeah? And for us that are working in IFIs, this is an issue that we are constantly bringing up with our clients. We do have some issues in some jurisdictions where the fact that the result of an adjudication is not binding creates some judicial issues in our countries, and therefore sometimes it's very difficult to persuade our clients to include a dispute adjudication mechanism. And we also have a little bit of an issue from a bank on how we actually pay this. However, I'm not going to exhaust this topic. It's going to be done by my panel members, and I am now very happy to hand over to Geoffrey Smith to start the day.
Good morning, everyone. Before I start my presentation, perhaps I could give you some information which was published yesterday, which I think emphasizes why we need to look at dispute boards and why FIDIC is keen to have dispute boards on all the projects where FIDIC contracts are used. Yesterday, the ICC, the International Chamber of Commerce, published their annual statistics for international arbitration run by the ICC. For many years, ICC and FIDIC have been very close because since the first FIDIC contract was produced in 1957, the dispute resolution mechanism foreseen in the contract was international arbitration with ICC. And up to 1999, you could say FIDIC was the main client of ICC. Most of their, very large part of their arbitration workload came from FIDIC. Since 1999 and the introduction of dispute boards, that has been less so. But even so, yesterday the figures showed that 40% of the cases that ICC was handling or received in 2018 came from the infrastructure and energy sectors, the two together. Construction itself was 27% of the cases. The average amount in dispute was $45 million. Now, when people go to arbitration, they spend a very large amount on lawyers. 10 to 40% of the amount in dispute is not unusual. I've seen cases where the parties spend more on lawyers than on the amount in dispute. So if you take 40% of 45 millions, that's $18 million. What can you buy as a procurement agency for $18 million? Do you really want to spend $18 million on lawyers' fees? We have nothing to show for it. You get an arbitral award 4 years after the project, tells you who's to blame. You have to pay perhaps the 45 millions if you lose. You have to pay your legal expenses, and you have to pay the legal expenses of the other party. So you could be wasting $18 million. So that is why, since 1999, FIDIC has been looking at an alternative way to deal with disputes, with the hope that we can avoid that wasted expenditure and we can settle disputes at a project level. So I'm going to go very quickly through what is a dispute board, the basis to it, how does it function, so that everyone in the audience, whether you had previous contact with dispute boards or not, has the same understanding. And then I'll hand over to Angelo, and then, as Jack said, we'd very much like to take questions and have an open discussion. So, where do I put my pointer? Here it is. So, a dispute board is generally composed of 3 neutral individuals, one if it's a smaller project, who are there to help the parties avoid disputes or, if necessary, to resolve the disputes. I say they're neutral. They are to have no connection with either of the parties. They sign a declaration to say they have no connection either with the contractor or the employer, as is known in the FIDIC contract. If a dispute does actually arise, then they have the power to adjudicate the dispute and issue a decision which is binding on the parties. The advantage is the decision is issued during the life of the project. I just mentioned that in arbitration, you get a decision, an award, 3, 4, 5 years after the project. What good is that to anyone, apart from knowing who is to blame? The advantage of a dispute board is that once you have a decision during the life of the project, you can make sensible economic decisions about what to do next. So you will hear various expressions used with respect to dispute boards. There are at least 4 different types, 4 different names used for them. The system began in the United States, where the dispute board only gives recommendations, or at that time only gave recommendations. They were not binding. It was up to the parties to take the recommendation or leave it. And in the United States, because of that, they are called dispute review boards. They review the situation and they give a recommendation. FIDIC, when it began using a system in the 1990s, decided that that was insufficient for international use, where often the government parties have difficulty in accepting a recommendation. They need something more than a recommendation. They need a decision. So in the 1990s, FIDIC made the decision to have a dispute adjudication board, where the board would have the power to issue a binding decision as well as recommendations. In 2005, the multilateral development banks produced the Pink Book, the special version of the FIDIC Red Book, and they changed the name from Dispute Adjudication Board to Dispute Board. I understand, but Jack perhaps can correct me if I'm wrong, that the word adjudication was dropped to emphasize more that the board is there to avoid disputes and not just to adjudicate. There's an overemphasis on adjudication. And then, as Jack just mentioned, when FIDIC produced new versions of its red, yellow, and silver books at the end of 2017, it changed the name again to Dispute Avoidance and Adjudication Board, to give equal emphasis to avoidance of disputes and not just adjudication. Now, so there we have 4 categories of dispute board, but we can categorize dispute boards in 2 other ways. The first one is what is called an ad hoc dispute board. An ad hoc dispute board is only set up when the dispute has arisen. It has no dispute avoidance role. It's very difficult to exercise a role because the dispute is already there before the dispute board is appointed. And their jurisdiction, the jurisdiction of the dispute board, ends as soon as they issue a decision. So they have a very short involvement in the project. Now, the other category, and I should just say that in FIDIC 1999, the Yellow Book and Silver Book, as they're called, they had ad hoc dispute boards. The Red Book, in 1999, had what is called a standing dispute board. And a standing dispute board, ideally, is set up at the very start of the project. And the dispute board members maintain contact with the parties, they follow the project, they visit the project every 3 to 4 months. And their jurisdiction ends not when the works are complete, but at the end of the guarantee period. So their involvement in the project could be for 3, 4, 5 years, depending upon the duration of the works. So since 2017, FIDIC uses a standing dispute board on all of its contracts, red, yellow, and silver. And there's also the Gold Book for Design, Build, Operate. It also has a standing dispute board. The reason is that we see that dispute avoidance is much more important than dispute adjudication. Dispute adjudication is much less successful, much less convincing to the parties than dispute avoidance. So the emphasis is now very much on avoidance of disputes. So how do we appoint the dispute board? Well, I said they are neutral individuals, so each party names one member or suggests the name of a member. You don't say, this is my man, this is my woman. It is, you suggest the name, it is up to the other side whether they accept that name or not. Once the two members are appointed, they suggest the name of the third person to act as chair. If there is any disagreement, which of course is possible, then in the contract there is an appointing authority named by the procuring agency who are charged with making an appointment. That appointment is final and conclusive. Once the entity, it could be FIDIC, it could be ICC, there are other organizations that will do this, once they give you a name, you must take that person. There are some disadvantages to that. One is that you are in a very difficult position to negotiate fees. It's very difficult to negotiate with someone when you must take him. So it is, I emphasize that it is in your own interests to try to agree on the choice of dispute board members. Once you have chosen the members, you enter into a contract with each dispute board member, a dispute board agreement. Each member has an agreement. Normally, it is signed by the member himself, by the employer, and the contractor. At the back of the FIDIC contracts, we have a set of general conditions for the dispute board agreement, and they also contain a set of procedural rules. They are FIDIC copyright, so they are not to be changed. If you want to make any changes to those general conditions, those procedural rules, you do it in the actual agreement, and FIDIC suggests a form of agreement which you are able to modify to suit your particular needs. So it's like you have the general conditions of contract for the works, and then you have a set of particular conditions. This is very similar. The particular conditions for the dispute board agreement go into the agreement itself and modify the terms of the general conditions. And that agreement sets out the role of the dispute board, the role of the parties, how you dismiss the dispute board if necessary, how you replace the members, and of course it sets out the fees. So once the dispute board agreement has been signed, how does the dispute board function? Now, here I'm only going to talk about the standing dispute boards because that is where we're going. The standing dispute board is so much more successful than an ad hoc dispute board. Everyone should be convinced about using a standing dispute board. So as I said, you follow the project from the beginning. You keep up to date with all the developments. You make the regular site visits every 3 to 4 months. You concentrate on dispute avoidance before issues develop. And then, if necessary, you make decisions which in the short term are binding, and then they will, or they can become final after a certain period of time if neither party serves a notice of dissatisfaction. Binding means you must comply. Final and binding means you cannot take it to another forum. The matter is closed. No arbitrator will have jurisdiction to deal with it. No national court will have jurisdiction to deal with it. It is settled. So how do you keep up to date? Well, the obvious thing is for the parties to send the dispute board documents. Copies of the monthly reports, the contractor's statements when he applies for payment each month, the interim payment certificates issued by the engineer, copies of claims, copies of variation instructions. The dispute board, under their dispute board agreement, will charge a retainer for reading those documents. You have to pay the retainer. So why not make the members work for their money? If you send them the documents, they will have to read it. They will be up to date at all times. If you don't send them anything, they are getting their retainer for nothing. And I've had both sides. I have some parties where they send me documents every day. If I'd known, I should have multiplied by my retainer by 5. Others, they send me nothing. I wait 3 months, I go on a site visit, don't know what's happened, they never send me anything. Surprisingly, those contracts have, not surprisingly, those contracts have more disputes. But it's much easier to avoid a dispute when you know what is happening. Now, the site visits, as I said, every 3 to 4 months, but also at critical times in construction, and if one party asks for a visit. It doesn't need to be a joint request, it can be one party. The visit usually lasts 2 days, and then you have to add on travel time for the dispute board members to actually get to the project. During the dispute board, the employer, the contractor, and the engineer are to be present, and they usually start with a meeting of all parties. The engineer and the contractor, and maybe employer, explain what has been happening, what are their concerns, and what are the current issues. Everyone then goes out on site and actually visits the work together, and then they go back to the meeting room and continue discussion and try to make progress on any issues which have come to light. Before leaving the site, the dispute board issues a report, which is usually very helpful to the parties to focus on the issues. I find personally it's one of the most important points, reading my draft report before I sign it and hand over. And the objective is to maintain good communications between the parties. Some of the parties tell me, we're glad to see you on site because it's the only time we actually speak to each other calmly. Because the people who are dispute board practitioners tend to be older, with grey hair or no hair, and it's difficult for younger people not to give them some respect and to take them seriously. So it's generally possible to have sensible, open discussion. And during that discussion, either during a site visit or even after the site visit, the parties together can ask for a non-binding opinion. Not just one party. If one party asks for non-binding opinion, it is advice. The dispute board would be advising one party. You cannot do that. So it's if both parties ask for opinion, you give it, but it's not binding. It's not binding on the parties. They don't have to comply. It's not even binding on the dispute board. They can change their opinion at a later date. And even if the parties don't ask for opinion, the dispute board watches for an opportunity to offer to give an opinion if it would help to resolve the dispute. And sometimes the parties won't agree to an opinion. Well, it's quite an easy way around that. Then you just say, well, what does the contract say about this? And put it up on the screen and read the contract together, and suddenly the lights go on. And the people read what the contract actually means together, and they find their own solution. So part of this, the technique, the role of the dispute board during his visits then, is to act a little like a mediator, taking any animosity, taking any aggression, listening carefully to the parties, turning around what they're saying into a more productive, more constructive approach. Now, in the FIDIC 2017 suite, there's a new provision, which is that the dispute board can meet one party separately if the other party agrees. Now, that in general is not well received by dispute board practitioners. Not many dispute board practitioners would accept to do that because you are running the risk of being accused later of bias. If you are asked to make a decision on an issue later, how can you do that if you have had a private meeting with someone? The other side will say, they told you something during that private meeting we don't know about. So most dispute board practitioners would not use that provision. So what about dispute adjudication if you cannot avoid a dispute arising? Well, the process begins with one party making what is called a referral. They send a detailed statement of claim to the dispute board and ask for a decision. And a copy goes to the employer, and a copy, I'm assuming contractors making the claim, and a copy to the engineer. From the date that the chairperson receives that referral, the dispute board has 84 days to issue a decision with reasons, very much like an arbitral award, but a little shorter, and done in a fraction of the time. In that 84-day period, the dispute board has to decide how many exchanges of written arguments there will be. Often the parties will insist on at least 2 exchanges, and there will be a hearing. Not always a hearing, but in a large number of cases there will be a hearing. The hearing is much less stressful and informal than an arbitral hearing. If any of you have ever been in an arbitral hearing, you know what it's like. You need a month's holiday afterwards because it is so stressful. But it's not like that for dispute board. A dispute board has, under the rules of procedure, has inquisitorial powers. That means they can ask their own questions, they can ask for documents, they can decide they will go to site to see a situation. They also have power to order provisional relief. That is things like giving an instruction to employer not to make a call on a performance security if that would make the contractor go bankrupt. So put a hold on a call on a performance security while the dispute board is reviewing the matter. But throughout all the proceedings, the dispute board must respect the rules of natural justice. That means each party must be treated equally, must be given an equal opportunity to present its own case and to present its defense against the other party's case. But once that decision is issued, as I said already, it is binding. The parties must comply. Why must they comply? Because they signed a contract which said they would comply. So if they do not comply, they are in breach of contract. Under 1999 contracts, it didn't expressly state that a failure to comply with a dispute board decision was a valid ground for termination of the contract. But that happened, and it was tested in court, in arbitration, and it was held that a refusal to comply with a dispute board decision was a substantial failure to comply with contractual obligations. FIDIC 2017, it is expressly stated, if you do not comply, the other party can terminate the contract. Now, you might not be happy with the decision, but you must still comply, but you can serve a notice of dissatisfaction, and you have 28 days to do that. If you don't do it within 28 days, the decision becomes final and binding, and as I said earlier, that is the end of the matter. You cannot take it anywhere else. Now, after the notice of dissatisfaction, you cannot start arbitration immediately. There is what is often called a cooling off period, a period during which the parties are to attempt amicable settlement. In fact, that period is often used very successfully. Quite a large number of dispute board decisions are subject to notices of dissatisfaction, but they never go to arbitration. The parties settle on the basis of the decision. Now, after the cooling off period, after this attempt at amicable settlement, either party can commence arbitration if no settlement is reached. But you can also commence arbitration to enforce compliance. It was a little confused under the 1999 contracts, but under 2017 it is very clear. You can commence arbitration immediately without a notice of dissatisfaction and without the need to attempt amicable settlement. That is simply to enforce compliance with the decision. Now, just a couple of slides to finish off. Is the process effective? Well, we as an organization, the Dispute Resolution Board Foundation, tried to gather some statistics. A very small survey, I must admit, but we are now going to take an outside consultant to do a much more professional and independent survey. But our statistics showed that when you have a standing dispute board that actively tries to avoid disputes, only 0.5% of issues go to arbitration. When you have an ad hoc dispute board, which is only set up when a dispute has arisen, 15% of issues go to arbitration. So 30% more likely to go to arbitration with an ad hoc dispute board than a standing dispute board that actively tries to avoid disputes. And when it goes to arbitration, 1.5% of the dispute board decisions are overturned by the arbitral tribunal. That tends to vary a little bit depending upon which forum you're using. The tendency to go to arbitration also is regional. There's much more likelihood to go to arbitration in Central and Eastern Europe than in Africa, for example. In Africa, very few, very, very few cases, dispute board decisions go to arbitration. Now, what else? Well, the Americans, the Florida Department of Transportation has a lot of projects, and it carried out surveys on projects with boards and without. It found that when they had dispute boards, the projects were completed for 4% less money, and they saved 16% of the time, which for a 3-year project is equivalent to 6 months. So you get your project, and the public get their project 6 months earlier. Now, if that is the outcome of a dispute board, why are they not used more? Why is there still some resistance, even though FIDIC has been promoting the idea since 1999? Well, one common point is that the parties, when they start the project, are on a honeymoon. They expect everything to go well. They don't expect to have any disputes. They say, we won't have any disputes. I've even had someone from one of the multilateral development banks say to me, it wasn't EBRD, we don't want a dispute board because we don't want any disputes. And then, of course, the parties are concerned about the cost and wish to avoid the cost, particularly because they look at the fees charged by dispute board members compared to their own salaries. And often there's a substantial difference. So there's a natural reluctance to enter into this system. But the costs are much less than the $18 million you're going to pay the lawyers in arbitration. I was in Tashkent recently giving some training, and someone in the audience from the Roads Department said he just finished an arbitration. It had cost millions. He said they had to pay millions to the lawyers before anything got done. Then they had to pay experts. And he said it took 4 years of his life. As a manager in the Roads Department, he did nothing else but arbitration for 4 years. Now, what other objections are raised? Well, often the parties don't budget for the cost. It's in the contract, but they've never allowed in the budget, neither the employer or the contractor. So it hasn't been financed. If you had included it in your loan application, it would probably be classed as eligible expense. Certainly it is with some of the MDB, and the budget is available to finance the dispute board. Because I haven't told you, you have to pay 50%. Each side pays 50% of the cost. The invoices are sent to the contractor, he pays them, and then he includes 50% in his application for payment, his statement submitted to the employer. And then often, one problem we see is a lot of employers don't actually have a system for appointing a dispute board member. How are you going to do it? Are you going to ask for a request for proposals? Some countries they do. Some countries it is done on a competitive tender process, although it's not very popular with dispute board members, of course. So those are some of the things we have to look at to make it more widely used. We also have to train more people because it's expensive at the moment because there are very few people doing it. So it's a question of supply and demand. If we have more people doing it, the price will come down. So the DRBF is now putting in place a scheme with FIDIC to train many more people as potential dispute board members. Just to finish off, I need to tell you how much the costs are, because otherwise this doesn't make much sense. Remember our $45 million dispute, up to 18 million in legal fees. Well, a $45 million dispute on a $100 million project is not unusual. It's about, not average, but it's not unusual. So a $100 million project, you probably have 3 dispute boards. And for a 3-year project, 3-year construction period, you should budget on a figure of about $1.2 million. If you have a smaller project, just 1 dispute board member, $250,000, $300,000, a 2-year project, say. So it's relatively high, but it's not much more expensive than the performance bond. You wouldn't think of having a project without a performance bond. You might never need it, but you pay for it because the contractor puts it in his price. You wouldn't have your project without insurance. You wouldn't wait till your house catches fire before you go to buy insurance. So although the dispute board costs appear to be high, in reality, they're good value for money. Thank you.
Now, I would suggest that we do take a few, if you don't mind, Angelo, I will take a few questions before we continue, because I think even though these 2 topics are obviously very much interlinked, I think it still would be interesting to start with a few questions, Geoffrey. And I will shoot off with one myself just to get things going. Yeah? And that is that I think the notion is that the dispute avoidance and adjudication board members are only looking at the technical aspects, making the project move forward from a technical point of view. But that is not the case. And one issue which have arisen, let's say, lately in the MDB world is the focus on gender-based violence. Yeah? And there is a proposal from, let's say, the World Bank, which I know that Geoffrey, you have been sort of instrumental in putting together, where the dispute adjudication board would play a role at looking at any form of gender-based violence and how that should be, let's say, judged. Maybe not the right word, but how to deal with these issues in the implementation of a project. And I wonder if you could mention a few things about this. Yeah.
Okay.
Yeah.
Thank you. Yes. How can I put this? FIDIC contracts contain quite a lot of social clauses. Now, the average FIDIC contract has 11 sub-clauses dealing with how you treat staff, how you treat workers, etc. The Pink Book, produced by the banks or on behalf of the banks, had 24 such clauses. And they have quite a lot of clauses which, in fact, it's very difficult to operate them. It doesn't say what will happen if a contractor doesn't comply. So being some concern at the World Bank about what you can do to actually enforce the social issues, but also the environmental provisions. And they had a problem in particular, a couple of problems in Africa, where workers were causing a problem, sexual problems with local community. And so the bank felt they had to focus in the first place on this aspect. It's now, the official term is SEA, sexual exploitation and assault. But if it works for this, then it will be used for other matters like land acquisition, resettlement issues, and environmental issues. So the idea is that in the contract, there will be strict contractual requirements for training workers and trying to ensure that they behave properly. So there will be a code of conduct, a model code of conduct which must be submitted with the contractor's bid. Each worker must sign a code of conduct. There must be training. There must be a mechanism for reporting allegations, and the engineer himself has duties in monitoring how this all functions. And the dispute board is to be given the role of checking that the parties comply with the requirements. See, when I go on a site visit, one of the first points on my agenda is safety. It has nothing to do with technicalities, but I have pupils. I have pupil dispute board members that come with me on site visits sometimes, and one of them pointed out to me, he said, you know, we should not even be in this building. We're actually on top of a powerhouse, and there's no scaffolding, no barrier around the powerhouse. And he said, if I was working for my previous employer, we would not be allowed up here. So it struck me that as dispute board members, we have a duty to deal not just with the technical issues, but also safety and the environmental issues. So now it's on my agenda. I ask, what is the situation? Are there any accidents? Sometimes I actually ask to see the safety officer. And so it's a similar approach. The dispute board, when they visit the site, must include in their agenda the compliance with these SEA requirements. Has the contractor complied? Has the engineer complied? Are there any problems? If he reports or she reports, the dispute board reports that there are some issues, then the employer will be bound by the terms of a loan agreement to refer the matter to the dispute board for a decision. The dispute board will then issue a decision about whether there's been compliance or not. They will not look at the allegation. They will not know what the allegation is. Was it an allegation of rape? Was it an allegation of something else? They don't know the details. That's for the police to deal with. But they will look at compliance. And on the basis of their decision, the World Bank will decide what to do with respect to punishment of the contractor and maybe even the engineer.
And this is where there is a little bit of a, let's say, from my point of view, a little bit of an odd twist to this, because when it comes to gender-based violence and not adhering to the contract conditions there, if you found being in breach, you can actually be sanctioned. But it only applies to the GBV, yeah?
For the time being.
For the time being, you know. And in my opinion, having worked with the type of projects that we are involved in, big infrastructure project over many years, the general issue about safety and welfare is of equal importance, you know. And I think that at the end of the day, if you have breached the conditions of the contract resulting in someone's death or injury, that should also be part of this.
I entirely agree.
Yeah.
If we can put in place a similar system for health and safety issues, I'd be very happy.
Yeah. Yep.
A dispute board cannot stand in the place of the police and carry out an inquiry about has there been a rape or not, and it cannot ask to see the victim and deal with the allegation. All it is there has been an allegation. Was it reported? Is it in the file? Has it been investigated? Has it been reported to the police? So looking at has there been compliance with what the contract says the contractor must do and what the engineer must do. So we don't know. We just know there's been an allegation, but we don't know the circumstances, we don't know the names, we don't know the full details, because we will end up in jail ourselves if we do, because we'll be taking the place of the police.
To put it in other terms, you know, if, let's say, the contractor was aware that there was a risk of let's say, gender-based violence, and had not taken appropriate action in line with the conditions of the contracts to prevent it, then that would be a sort of breach.
Yes.
The actual fact that it happened would be, let's say, and the consequences of that would be a criminal issue. Yeah.
Yes.
This is also relevant if nothing has happened. I mean, you have to manage risk independently of whether something happens or not, right?
But which is why I have a compliance system. It's not just if there's an allegation. You have to check whether everyone is being trained regularly. Have they all signed the code of conduct? Is the system in place? Is the contractor must put in place his environmental and social monitoring plan? Is he updating it regularly? Is it being reviewed by the contractor, by the engineer?
So it's independent of whether a sexual assault has happened or not.
It's a system which is being policed, you could say, by the dispute board to try to change a mindset, to put in place a system which limits the risk.
Georgopoulos from the University of Nottingham. You mentioned that some of the decisions that can be final and that they cannot be challenged. But doesn't that very much depend on the jurisdiction, in the sense that if I'm not wrong, and this is the same with arbitral awards, there are certain jurisdictions, excuse me, where courts, they're not even willing to enforce the contractual clause that says we will not, once there is a final decision, we will stay and we will not pursue other avenues. So if you are in a jurisdiction where courts take themselves very seriously, there is a possibility of taking things even further if one of the two parties is not happy and would like to sort of exhaust all the chances, as it were.
Yeah, in a short presentation, I don't want to go through all the exceptions, but obviously there are some countries where the finality of the decision will be challenged. What the outcome will be, we don't know. In some countries, judges and courts are very jealous of their power, and they don't want that being taken away by someone else, even though the parties agree by contract that it will become final if they do not comply. And that has been tested in many jurisdictions, and it has been upheld.
Alfonso Pelosi from Italy, Salini Impregilo. My question is, when a notice of dissatisfaction is served, and during the cooling off period, when the parties try to have an amicable settlement, has the dispute board any part in it, or should it be outside of it?
Normally it is outside. It would be difficult for the dispute board to be involved during that phase when it's a standing dispute board, because it may have further disputes in the future and must not compromise its independence during that phase. If it is an ad hoc dispute board, then I can see a possibility of a dispute board being asked to be involved as a facilitator or mediator during that phase. But I wouldn't recommend it for standing dispute board.
I have another question. The 2017 FIDIC, the second edition, wants the arbitration to start within a fixed period, quite short, after a notice of dissatisfaction is served. What is your personal opinion about that?
It's good news for the ICC because people will be forced into starting arbitrations, whereas previously they may commence the amicable settlement during the period after the notice of dissatisfaction, but it doesn't mean they reach a settlement in that period. It can take 6 months or longer to reach a settlement. And if you are forced by the contract into starting an arbitration, otherwise you lose your rights, then I will put aside my DRBF hat and put on my lawyer's wig.
Okay, sorry, we are, this was very good to warm up a little bit, if we need that. But I think we need to move on to Angelo, who is going to talk about how do you actually select the dispute board. Yeah?
Ladies and gentlemen, good morning. My name is Angelo Bianchi. I'm here as a procurement specialist. I'm an independent consultant working as providing technical assistance to contracting authority all along the procurement process. For the EU, the procurement process includes preparation of tender documents, evaluation of tenders, and contract management. I'm going to focus, my presentation follows, and I have the honor to follow the presentation of Geoffrey, who is a DAB, an expert DAB, while I'm focusing my presentation on the difficulties in appointing the DAB. because we are all aware of the benefits coming from the DAB, but in reality, we find a lot of difficulties in appointing the DAB. And my presentation will be exactly focused on the analysis of the contest. I want to highlight some main points that Jeff and also Jack highlighted. You know that the DAB is largely used and it gives a lot of benefits in the large infrastructure projects. On this, we give it for granted. Consultants, contractors, multilateral development bank are strong supporters of the DAB. It's a powerful tool to resolve disputes, but in reality, and the new suite, 1999, recommends an ad hoc, the new suite, 2017, recommends a standing DAB on all forms of contract, while the old suite recommended an ad hoc DAB on Yellow Book and a standing DAB on Red Book. But in reality, we all know that the benefits of the DAB are real, are higher if we have an early appointment of the DAB. If they are put in place when the disputes are not really problematic. And we all know that the Multilateral Development Bank encouraged the appointment of the DAB at an early stage. But in reality, Geoffrey was highlighting that at the beginning of the contract, the employers, especially the employers, believe that they can manage the contract without the DAB. They are concerned about the cost of the DAB. They don't believe that the cost of the DAB is an investment in terms of future saving for avoiding disputes. So what happens? That in addition to these common and usual difficulties, we have another problem, that especially in projects financed by the European Union, external contracts, we have the employers saying that the appointing of the DAB members is not consistent with the procurement rules and legal framework of the Prague, for example, the practical guide, which is the handbook for procurement in contracts financed by the EU, the external contracts. So how we can harmonize the principles of FIDIC? Jack told us that one of the main principles, golden principles of the new suite is that we don't have to modify in any form substantial the substantial structure of the FIDIC contract. But in reality, if we go on the Prague, for example, the practical guide for procurement and for contract management of EU external contracts, we find here another binding principle, which is competition. Competition is not an option, it's a principle. It means that for example, when we have to appoint experts, we cannot do on a direct selection basis all along the project cycle, from the identification up to the closure. Even, for example, I was observer in a large EU-funded projects, small contract, more than 20,000 euro, but I had to be appointed following a competitive procedure, which, according to the Prague, the standard procedure is the framework contract. So my presentation will be focused exactly on these difficulties. And here you find just a list of my recent projects in EU-funded projects, large infrastructure. You see here the amount of the contract is not small, from 16 million up to 220 million. And all the list of my EU-funded projects, including the project co-financed by JEC, by the EBRD, we had no DAB in place. That means there are difficulties in practical terms in appointing the DAB, and this is a problem of procurement. We are here in a procurement conference, and so we have to, yes, of course, DAB members are strongly supporters and they see the benefits of the DAB, but we have to provide advice to have them in place and to have them effective and efficient. So, my main problem, my presentation is focused on the main problem. No DAB in place, it doesn't mean that we don't have contractual problems. It means that we have a lot of problems. We have slower projects, we have delays, and we have additional costs. So I'm convinced 100% that DAB members are essential, or at least the mechanism. So let's have a look. My purpose is the identification of a feasible and efficient procurement procedures that harmonizes the competition principle, for example, of the European Union, with the principles of the FIDIC that sometimes tend to neglect some procurement aspects. In order to do this, I'm going to present a real case study of not a small infrastructure. It's a very large and complex infrastructure carried out I completed recently, at the end of the year 2018. The contract amount is large, $210 million, euro. And it was completed with no DAB in place. And in addition to this, within the budget, which is almost a miracle, and according to quality. It's not my opinion, but the opinion of technical experts. This is a flag project in the Balkans. Most of our students know this motorway very well. It's a very complex project, not an easy contract. 28 kilometers long of a section of a new motorway, including of the new Pan-European corridor, one of the new Pan-European corridors, co-financed by 3 major international financing institutions, including the EBRD. We had 35 million euro of grants from the IPA funds of the European Union, and in addition to this, a co-financing by EIB plus EBRD. So it's an interesting case study, also because it's quite complex from a contractual and technical point of view, because includes, it's a two-lane double carriageway motorway, 28 kilometers long, I told you, including 6 major, very high bridges, 2 twin tunnels, 1.2 kilometers each, and 8 million cubic meters of earthworks, so it's not easy, eh? And you can see it from the pictures. And what happened in this project? Of course, like in some other projects, in order to give you, first of all, an idea of the context, first of all, I want to tell you that this project was carried out, of course, under FIDIC formal contracts, Red Book traditional approach, 1999. It included the redesign of 5 out of 6 bridges, so it was not an easy contractual management, proposed by the contractor, approved by the engineer and the employer. The engineering team was an international consulting firm, very good international consulting firm. It was there on site with 20 full-time experts, 8 expatriates plus 12 local experts, and other 25 technical staff, inspectors, administrative staff, and so on. And the amount of the engineering services was contract was 5% of the total contract amount of the works. I want to highlight this because the DAB are not supermen. It is very, very important that the preliminary work is well done by the engineer. That's why I'm including information about the engineer. The engineers team included a FIDIC expert, short term, of course, an English consultant, very good. And this is a very good provision because all along the project we needed the technical and expert opinion of the FIDIC expert of the engineer. The employer was supported by a board of local experts, and this helped in having a prompt decision mechanism of the employer. Let's go on. Usual story. At the beginning of the third year, the two parties had carried out the project, and they believed that they were able to carry out the project without no DAB in place. They had delayed the appointment of the DAB up to the moment that at the beginning of the third year, we had no DAB in place. But the International Financing Institution realized, the coordinator of the, he was brilliant, he realized that the project required DAB service. At the beginning of the third year, he took a very important decision. Looking at the fact that two parties were not able to appoint the DAB, he decided to appoint what he called a technical audit team, including 4 senior experts, following a competitive procedure of the European Union. So, 4 members of the European Union technical audit were awarded this contract. Our contract was 3 years. 3 years, the duration of this service contract. The audit team, technical audit team, appointed by grant of the International Financing Institution, included 4 individual senior experts, not pupils. The team leader was a very experienced highway engineer, British highway engineer, 30 or 35 years as team leader in large infrastructure projects carried out under FIDIC conditions of contract. I had the privilege to be the contract engineer. And then there was a bridge specialist and a tunnel specialist, because the bridges were 5 important bridges, high bridges, and tunnels had their own problem. You see here the picture. Let's have a look at the terms of reference of this technical audit team. If you compare the terms of reference of our team, it's very, very similar to the general obligations, the general conditions of contract for the DAB, because we had to do, of course, to declare that we had no conflict of interest, of course, to be available for periodic visits all along our standing, let's say, contract of 3 years, and carry out periodic visits to the site. If I can be a little bit critical on what Geoffrey told me, I don't think it's realistic that with visits of 2 or 3 days you can become really conversant with the contractual issues of the project. In reality, we carried out 3 important site visits of almost 40 calendar days, 35 working days altogether. And we met, of course, with the employer, contractor, engineer. We visited the site many times. We visited the laboratories and other technical and contractual experts. We collected, of course, all the contractual documents coming from and it's not possible to have them by email because they are cubic meters of documents. You have to be on site. And of course, we collected the contract, which was 3 cubic meters of documents. And then in addition to this, monthly progress reports, reports of the supervisor, variation orders, IPC, and so on. At the end of the story, the International Financing Institution asked us opinions on contractual issues. And we provided 3 main opinions at the end of the 3 missions. And the nice thing was that the first mission was 45 days. We issued our opinion in November of the first year. And the nice thing was that at the end of we were there to discuss about contractor claims, very important contractor claim, because a very important payment had been suspended. I don't enter, of course, into details. But the nice thing was that following our opinion, in December, all parties agreed on our recommended option, and the project moved on. So we went back on site the second year, more or less the same period, November, once again for 30 months, 30 days, working days. And we provided our second opinion regarding this time a very controversial variation. We had to stay there 1 month because the engineer was fighting in order to discuss this variation for months, and we pushed the decision. So when I see that the site visit is 2 days, it seems to me a little bit unrealistic. And after our opinion, once again, the variation was settled and the project moved on up to the third mission that we carried out, and it was very, very important for the organization of the defects notification period, because even the engineer was proposing something that was not consistent with the control, the proper control of the project. So we provided an opinion also on how to organize the control of the supervision of the contract during the defect notification period. Conclusions. Conclusion number 1. My conclusion for your discussion is that FIDIC can issue golden principle, but FIDIC should also harmonize their golden principles with the legal framework of the countries they go and with the procurement procedures of the international financing institution that are going to finance their contracts. You know that FIDIC is not the standard form of contract, for example, for EU-funded projects. Prague has his own, their own form of contract. But we as procurement specialists, of course, we recommend always, but we have to go under derogation in order to use the FIDIC. And we had to accommodate some parts of the particular condition in order to be consistent with the Prague. So international financing institutions should, of course, they are supporters of the DAB, but they should realize that if they are so strongly supporters of the DAB, maybe they should consider that the employers that have to pay half cost of the expert of the DAB, maybe they would be more willing to appoint immediately the DAB members if this cost, which is very, very little. You can imagine that our technical audit team costed 0.01 of the total contract amount of the works. So it's like the cost of the oil, 300 euro in a Ferrari of 200,000 euro. Of course, if with this cost you receive that the Ferrari works, maybe the international financing institution who give grants for the identification, for the technical assistance during evaluation, if they realize how with so little cost they can produce efficiency and effectiveness in contract implementation, they are willing to finance as a grant this technical assistance. There is no reason why these experts, in my opinion, have to be selected without competition. The European Union says that competition is one of the procurement principles. Why do, even if this selection is jointly appointed by two parties, how can I compare the experience of for example, Geoffrey with the experience of Di Capun or another famous DAB member that I know and I've met in my, without competition? Of course, there is someone who is more expert of railway project. There are some other DAB members that are more expert of road project. And there are others that are more expert of hydraulic projects. So why we have to select without competition? Competition does not mean that I want to lower prices, but I want senior experts, qualified, highly qualified members, appointed on a selection basis that have competition. It means quality of and qualification of the expert as the main factor. And so my question, my procurement question. We are in a global procurement conference, so I have a procurement question for your discussion. That is this one. Are DAB, sorry, Geoffrey, no reference to your experience, which is, of course, I don't have any doubt on that. But are DAB members a priestly class of experts that must be selected without competition? You know, on the left-hand side, you had 4 experts, more than 30 years experience in international projects, so they are not pupils. They had to be awarded following an European competition, which was very effective and efficient because the framework contract requires 3 working weeks, 21 calendar days to select senior experts. So it's a very efficient, Aris knows very well the framework contract. We were not paid a small salary. We were not selected on the basis of our small salary. We had our remuneration, which was fair. On the other side, you have members that want to be selected with a jointly selection because they are, they believe, and I'm sure they are, considered the most qualified expert of the sector. So, final table with a comparison and maybe some recommendation. First of all, the international financing institutions, the multilateral development bank should not neglect the fact that the appointment of the DAB is often delayed. Also in very large and complex projects, we have a lot of difficulties in selecting DAB members. While on this case, which is not, of course, the solution, it's just for discussion, the, let's say, DAB equivalent was appointed by the IFI in exactly 21 calendar days, 3 weeks, so very prompt. At the moment they realized the project was in a critical situation, 3 weeks after the team was in place, on site, for 35 working days. Employers are concerned about DAB costs because according to FIDIC rules, they have to pay half of the remuneration. So, considering this is 0.005% of the cost of the contract value, as highlighted by Geoffrey, there are a lot of advantages of having these services. Why IFI don't consider to take over the cost of the DAB as an investment instead of being supporters and put this cost on the shoulders of the employers? And then DAB Suite 2017 risks to be considered a priestly class appointed without competition. I'm not saying that we have to select DAB members without any qualification. We can also require certification or something like, but why without competition? We have to do it. When we manage public funds of the European Union, we have to follow and be consistent with the competition principle. Finally, the appointment of the DAB at the moment in EU-funded project risks to be non-compliant with the public procurement rules. Alfonso Pelosi is here. He was technical assistant in the Ministry of Transport of Turkey. He followed a lot of works contract financed by the European Union, very large, 350 million, 400 million. All of them are without DAB. This is not good, but if we maintain the idea that the expert can be selected without competition, we will not have any DAB members in place in these complex and large contracts. Thank you very much.
Right, thank you very much. This is definitely providing a good ground for discussion, I'm sure. And I will start by saying that probably I would choose the Ferrari, but that's okay. Obviously Italian, yeah? Yeah, exactly. No, I think just a reflection on what you were saying. I think for me there's one very fundamental difference here, and that is that in your case about the experts appointed, they were appointed by the IFI, as I understood. Yeah? So it means that they are working under the conditions approved by the IFI, and is not really part of the contract. So they become like a lender's monitor, which is actually something that Geoffrey and we have been discussing several times in the past. Let's say the key difference between lender's monitoring and DAB, and if we could in any way sort of merge this sort of the objectives somehow. Yeah? And that is something that we see in EBRD, that the use of lender's monitor, the sort of group of experts which works on behalf of the IFI to support the project and making sure that it's implemented in time and providing the key knowledge, that we see less and less the use of that, and it's something that we would like to impose from the IFI side, but that doesn't take away the importance of the DAB, because I think we are all very supportive of that, let's say, as a fundamental principle. I think that is very important. And let's say, to toss back the question, just to provide the basic for discussion, I could say that, well, at least for half of the IFIs, if you now can divide one individual, but for half of it, it's actually part of the contract. So you wonder if you need to, let's say, a contractor, he can choose any subcontractor that he wants, in the contract. So then you could ask the question, well, why does he need to have a competition for the adjudicator, that's the DAB member, at least on that side. On the other side, the client, who has to pay for at least 1.5 of this, needs to follow the public procurement regulations. But I am wondering if this is not something that needs to be looked upon from the point of view that is it is an instrumental part of an agreed contract, and from an IFI point of view, we have agreed on those conditions. So the question is, well, why shouldn't we finance that? It doesn't make sense if we wouldn't, in my opinion. But then comes the next question. Why should that be by grant? If this is a very instrumental part of the contract that we have agreed with the client, then I think at the end of the day it's part of the loan amount. It's part of what you consider being good practice for the implementation of the project. In the same way as we consider, let's say, from a bank point of view, which was the reason why we worked on the development of the Pink Book. It was not really at the end of the day about changing the general conditions of the Red Book. It was to ensure that all those issues which are important for the banks, such as environmental, health, social safety issues, were properly in integrity, were properly included in all the contracts. Second, it was to ensure that by buying the license, we could actually allow clients to use it for free without going to FIDIC and pay for it. So that was just a few reflections from my side. I'm going to start where I've sort of abruptly finished off before.
Yes, good morning, gentlemen. This is Mohammed Al-Gherni from SABIC, a petrochemical company from Saudi Arabia. It's actually my pleasure to be here today and yesterday for this conference. Special thanks for all these people after this event and all the speakers yesterday and today. Actually, I'm talking here about commercial run and maintain contracts, because I'm working as the senior manager for site technical services, managing more than 320 contracts, value $3.5 million. Simply, special thanks for Smith and Angelo. My question simply, we normally have a dispute and deviation from technical, for the all technical or term and conditions between two parties. From our side as a procurement, we have three parts. We have commercial, which is handled by procurement, and technical by our partner or client, and there is a legal also part for to sign and go for this contract. My question, how, from your experience, how we can go through this dispute or dilemma and successfully, your suggestion, recommendation, your reflection, without firing the audit or the legal consultant? This is my question. Thank you so much.
You mentioned the disputes are technical, but my experience, certainly in construction, is that the disputes are often a mixture. They're a mixture of legal interpretation, bad drafting, particularly in particular conditions which have not been thought out properly. They may, well, so it's technical, commercial. It could be evaluation. How do you actually price something? How do you price a change? There's a disagreement over that. As I said, technical and legal interpretation. So it's often a combination of the three. Now, that has an impact on how you're actually going to resolve the disputes, because if it is purely technical, you can take a technical expert who can give you an analysis and come up with a clear black and white answer, who is right, who is wrong. But when it is an interpretation of a clause, and particularly where you have conflicts between different documents in the contract and how are they to be interpreted, then it's a different skill, and the answer is not necessarily black or white. And so you may need a team of people or people with mixed skills to be able to help you to resolve that. After that, it depends how long is the duration of your project. We have been talking about dispute boards in the context of construction, because that's where they really started. But they are now used in the aerospace industry, they are used in software, they're used in insurance, the oil industry is beginning to use them, and they're used in the defense industry, where we have long-term contracts, and we want to maintain a relationship. We don't want people running off to court every 2 weeks. You know, it's like getting married. You're married for the rest of your life, and you have to make it work. If every time you have an argument, your wife runs to see your mother-in-law, then it won't work very well. So there has to be some way of accommodating the different viewpoints. So you need to develop the structure according to the duration of your contractual relationship. And dispute boards are particularly suited to any long-term relationship.
I understand that we had excellent presentation of two different systems. One arbitration in one contract system, which is FIDIC, and another monitoring, not auditing, according to my knowledge, monitoring system, which is contract-based. So, according to me, this question, procurement question, is not to be, addressed, because one versus the other is not, they are not compatible to me. But you presented two systems of solving disputes. But I wonder, do you have statistics of frequency of that monitoring cases or that arbitration cases compared with classical appeals or lawsuits in public procurement? So I'm interested if you have the frequency and relation of percentage, of ratio to that system that most of the common people in procurement are using.
From our point of view, dispute board practitioners, it is quite difficult to collect statistics. One reason is that we only have statistics where there are dispute boards. We don't have statistics about projects that don't have dispute boards. So we can only collect part of the information. Secondly, we're heavily reliant upon information from our own members. And when we present our statistics to the banks, they are skeptical because we are biased. Are we giving a true reflection when we're asked to comment, are the users happy with the system? course, we say, yes, they are. So it's difficult for us to give very, very objective and conclusive statistics. But as I said, we're about to set off in a study with an independent consultant who will try to come up with some sort of baseline that everyone can refer to.
Sorry, I want to highlight that it was, I hope, very clear in my presentation that I do not confuse DAB with technical audit. My presentation was exactly designed in order to show you some problems that should not be neglected by the multilateral development banks. We can speak about the benefits of DAB, but in reality we do not have DAB in place in EU-funded projects. So I was trying to ask everybody, because we need a systematic solution which cannot come from procurement specialists. Maybe it can come from the contribution of DAB experts, multilateral development banks, and procurement specialists providing technical assistance to the employers and describing the real problems. So it's not, sorry if I tell you that it's very clear to me that the DAB is different from a technical audit team. I was just showing you that our terms of reference were very, very similar to the terms of reference or general obligation that a few minutes ago Geoffrey gave us. So why don't we think that maybe the name is different, but the mechanism maybe gets to the same results? And if this result is good, because we completed the project within the time, within budget, why don't we consider that the golden principle is in reality not harmonized with the competition principles of the European Union, and work on that in order to find a solution, in order to harmonize them? That is my provocative. I don't want to confuse the DAB or monitoring activity with the DAB. That's clear to me. I told you that was a trick used by the brilliant IFI when he realized that there was no DAB in place and DAB services were needed, which is completely different. Sorry.
Totally agree. Fundamentally very important issues.
I just want to say you kind of hit on the holy grail of procurement monitoring and who pays for it, and that's something that not just you struggle with in infrastructure projects, but I have seen that all over the world, right? And is it an international organization like the EBRD or the World Bank who should pay for that? Is it the company? Is it the government? And I would love to have a conversation about at that point, because I think at some point, because I don't think no one has found an answer to it and what makes it actually sustainable over the years. And I had a question for you. The reports that you are issuing, were they available to the public or the communities? Because I think it's really good information to have for people that, you know, if a project is running on time and within budget, or if there are delays. Was that anything that at certain points was made available?
I can tell you what was the practice used by this the project manager, the project manager of the International Financing Institute. He required us specific opinions on three main issues, contractual issues, that were technical and legal matters, so of course, mixed. Of course, we provided you know, interdisciplinary opinion, and this opinion went to the International Financing Institution. The International Financing Institution informed and sent this opinion to the parties, the two parties and the engineer, and the result was that the conflict was settled. I can give you the result. The end result was that our opinion was considered the best recommendation, and all parties took a prompt decision, and we avoided the contractual claim and a contractor's claim, and the contractor claim was withdrawn by the contractor.
Okay. I do apologize, but I am Swedish. And I am very often confused with the Swiss. The Swiss are very good with watches, and we are too in Sweden. And I like to start on time and finish on time, and it's actually 4 minutes past 11, so 4 minutes we are infringing on the coffee. But it is also the time when you have 1 minute to improve your makeup and meet up just outside the main entrance. My makeup, it takes more longer time, but for a photo shoot, you know. So we are going to meet, if I understand right, just outside here, now, directly, exactly, before coffee. So see you there, and thank you very much, a big applause.